First, we need to learn about intellectual property and software licenses. In practice, this means a focus on the concept of copyright. Copyright both restricts and grants rights to users of software. The creator or owner of the software possesses the copyright, and any users have to have a license in order to legally use it. By owner, this could be an individual or a company or some other legal entity. Please note that this chapter does not require a legal background. Whilst I discuss some concepts from law, I will do this in a way that does not require any previous legal knowledge. By the end of this chapter, you should be able to understand what rights apply to software and what that means for open source software. Intellectual property laws apply to software just as they do apply to other products and services. Intellectual property comes in various forms. These include copyright, patents, and trademarks. We will be focusing on copyright, which protects original works of authorship. In one sense, the software is protected with roughly the same approach as a written book. These are both creative items authored by one or more people. Copyright around software applies to the expression or implementation of the software. In other words, it applies to the source code or binary code. The original author or authors own the copyright and therefore have legal control over the original software and any derivative works. The author can choose to provide a right to allow others to use the software. The right granted may allow a user to use the software in any way the user might want at all, or the author may choose to grant more restrictive terms. Authors usually choose terms with some conditions around use. These terms are usually expressed in a license agreement, a software license agreement. As we have already learnt, copyright is an important concept in software. It helps to protect authors' rights and provide grants or restrictions to users. However, it is not the only type of intellectual property that applies to software. In addition to copyright, the software may also be covered by patents. While copyright applies to written software code just like it applies to a written novel or screenplay, patents protect functionality implemented by that written code. In other words, a patent applies to a technical method of operation rather than the abstract idea. Patents cover how a software program accomplishes something, how it works, but not the idea or purpose of the program, such as a word processor, a web browser, etc. Take, for example, a program that displays an image on a computer screen. A patent could cover the technical process of decoding an image file so that it can be displayed. Another patent could cover the technical process of applying a specific filter effect, such as sepia, and so on. Copyright arises automatically as soon as the software is written. Patents, in contrast, have to be applied for through a lengthy process and only apply to new inventions. If you're a supplier or customer and want to use the specific functionality implemented in a product and it's covered by a patent, then you may need to get permission through a patent license. This could be a standalone license or a section in another license, say the software license. The licenses may describe how you can use, share, modify, sell, or import the technology, or have other requirements and limitations. Patent licenses are usually specific to the functionality being licensed, and therefore vary significantly from case to case. A patent license may be required even if you independently implement specific functionality. In other words, patents apply regardless of the origin of the software, as long as the specific functionality is implemented. A license is the way a copyright or patent holder grants permission or rights to someone else so that they can use the material of interest under a set of legal terms and conditions. License conditions can include types of use allowed and how it can be shared or used for business. For example, commercial or non-commercial or educational use only. How the material can be distributed, i.e. the medium or format of distribution. How others can make use of the material, whether they're used wholly or as a derivative work. The geographical scope of where the material can be used or sold can also be specified and limited as well. There can be time limits on the rights of use of the software. And all of these terms and conditions often apply to non-open source software. In contrast, open source licenses typically have fewer conditions than proprietary software licenses, but the conditions they do have tend to focus on the conditions for redistributing the software to others, which is something proprietary software licenses tend to prohibit entirely. The T's and C's must be followed in order to use the materials under the license. Typically, if the conditions are not followed, then the license terminates and the right to use the materials is lost. A license may also include contractual terms regarding warranties, indemnification, support, upgrade, and maintenance.